Welcome to Faith and Politics, a show dedicated to discussing issues surrounding the intersection of church, state, and politics, and the examination of whether you're allowing your faith to shape your politics or your politics starting to shape your faith. In other words, what do you do when God and government come face to face? Let me introduce you to our panelists for today. First, we have Mr. Todd McFarland, Deputy General Counsel for the General Conference of the Seventh-day Adventist Church. We also have with us Mr. Tim Schultz, the president of the First Amendment Partnership, an organization dedicated to protecting religious freedom for Americans of all faiths. We also have with us Mr. Justin Giboney, an attorney, political strategist, and co-founder and president of the AND campaign, and Mr. Vilo Weiss, who's the director of public affairs and religious liberty for the Indiana Conference of the Seventh-day Adventist Church. Gentlemen, good having you here with us and looking forward to our discussion today. You know, Title VII of the Civil Rights Act of 1964 is really the foundation that really helps to extend all of these practices of protecting against discrimination of religious observance or any type of practice of a religious belief. You know, we have situations where if you have a certain religion, your employer has to be able to accommodate you in some way simply because it is part of the law. And once you actually let an employer know that there is an issue, they now have a responsibility because of Title VII to be able to help you to deal with that aspect of your observance. You know, Todd, we talk a lot about what goes on in the area of protecting people and accommodations, whether it's Sabbath, whether it's other religions. And we want to make sure that our audience understands the foundation of what really got us here. Tell us how this works and really how we end up being protected as it relates to our religious beliefs.
Sure. So the Civil Rights Act of 1964 was the major civil rights act in this country coming out of the civil rights era. It was a Kennedy bill that then President Johnson got passed, and it was a sea change in how this country protects people based upon what we now call protected categories. Of course, at the time, the major motivation behind it was protecting on race, national origin, and color. But then they also added other protected categories, including sex and religion. And the religion category originally just simply said religion was protected, just like all the others protected categories: sex, national origin, color, and race. However, there then became a question about, well, what does it mean to protect a person's religion? So you could put a sign in the window that says no Seventh-day Adventists need apply. That would be pretty clearly illegal. But how about a sign or employment requirement that says that you have to work on Sabbath? You have to work on Saturday. And for Seventh-day Adventists to keep that from sundown Friday to sundown Saturday, for an observant Adventist, that would be the equivalent of saying no Adventists need apply. And Congress cleared that up in the 1972 amendments, and it now says that religion includes not just that status, that being religion, but also its practice and belief. And so if a person has a religious practice, that gets the same level of protection as just a person being part of the religion. But there is a caveat on that, and we'll talk about that a little bit, and that is employers don't have an unlimited obligation to accommodate a person's religious practice, only if it would cause an undue hardship.
You know, Tim Schultz, when we talk about that concept of undue hardships, how do we unpack that? Because any employer could say, listen, the moment you cause me to do something that takes me off of my point of how I want to move forward, that quote unquote could be an undue hardship. How do we unpack that to let people know what the real aspect of that really is?
Well, so the whole history of this is that the United States Supreme Court decided a case in the late 1970s called TWA versus Hardison, which really gives employers a lot of deference in what they say a hardship is. And I think that decision was decided wrongly. And I think the deference is too high. I think that, frankly, employers ought to presumptively accommodate their employees' religious practices. Many actually do. And it's too bad that the law has to be used to force them into that. But I also think that we need stronger protections in the law, because I think the Supreme Court got it wrong 40 years ago.
So if the Supreme Court got it wrong potentially 40 years ago, Justin, and somebody like yourself who's also a practicing clergy, how do you end up helping people to understand when you have parishioners and those that come to you and say, we want to be able to protect ourselves, but we're so concerned that if we say anything, we may end up losing our jobs? Where do we find a balance to give people the fortitude and the strength to want to move forward and know the law protects them?
Yeah, that's a really good question. Education is a major part of this. A lot of people just don't understand the foundation of the law. I thought that background that we got from Todd was really helpful to help people understand, okay, this is why, because employers need to know and others need to know, this is why these protections exist. And then to let the parishioners in our churches and others know, here's what you can do and here's what you can't do. Here's where you're protected and where you might not be protected. And so we can all move forward in a better way. You know, one of the things that about freedom and actually interacting in a healthy way is knowing what to expect, knowing what the regulations and guidelines are for our interactions. And I think we could go a long way in churches and elsewhere, just educating people on the need for those protections and also where those protections begin and end.
You know, Vilo, I know you sit in a space where you probably have parishioners that touch base with you from time to time, letting you know they have accommodation issues. How do you start helping them, and what is the process, and what is the information that you've seen that maybe they really didn't understand before they got to you?
Well, for starters, we have a variety of letters dealing with different fact patterns that we have the employee give to their employer. We follow it up with a pastor's letter, and most of the time that resolves the issue. Thankfully, I've had to write a letter or two. Now, I don't explain what undue hardship means to the employer. I just say they've got to accommodate unless it's an undue hardship. That's for their legal counsel to educate them, and some are not very well educated, and that's. So we've had a lot of success, for which we're very grateful and thankful.
You know, Todd, you're somebody who kind of goes across the country dealing with these issues. Have you noticed that there are a number of employers or even government entities that simply don't even understand how this law really works?
There are. Now, I have a little bit of a skewed view because in our structure, I only handle cases once they get to litigation. So, you know, the employers that do understand and do accommodate, I never see those. But yes, you know, most of the time when we're talking to these employers and government entities and taking depositions, the situation that we're dealing with is often the first time that they've ever had a religious accommodation request. Not just the first time they've been sued over it, but the first time anyone's ever asked. And there's almost always this sort of scramble of, wait a minute, what is this? What's our obligation? You know, the reality is, fortunately in the United States, of, you know, the claimed discrimination under Title VII, religion only makes it about 3% of that. Now, it's not just holy day accommodations that we're talking about, right? There's also what we call groom and garb case, so people may want to wear a hijab or another form of clothing, or they may want to grow their hair out, or may need a beard or some type of facial hair. And so there are other types, prayer requests, time off to pray for Muslims and others. So you see a lot of different types of requests, but still collectively, they only make up a little over 3% of the total forms of complaints of discrimination under Title VII.
So it sounds to me like, and Tim Schultz, I want to put this in front of you. One of the things sounds like there's a real education that has to be out there, not only simply for the employers, but also for the employees. One of the things that we see all the time is individuals who are too afraid to say something. You know, so how can we go about maybe making this information even more available, or should there be a requirement that the employers make this information more available to its employees?
I think the law is unlikely to change, at least, for those kinds of disclosure requirements. I would recommend that your listeners follow the work of the Religious Freedom and Business Foundation. This is an organization that promotes workplace religious freedom to employers, to big Fortune 500 companies. They've had a lot of success in doing so and increasing religious accommodation. I think that that's the best way to do this. It's not the difficult task of changing legal requirements, although, again, I do believe that TWA versus Hardison should be overturned. It's more that employers should be educated about how, accommodating employees is actually good business. And I think no one is doing that better right now than the Religious Freedom and Business Foundation.
You know, Justin, it almost seems like the real education should be going back to the religious groups, those organizations, whether you are, Adventist or Hindu or Muslim, to let them know that there is a law out there that can protect you. And if you're unwilling to step forward, it's going to be very difficult for people to assist. So it sounds like maybe that's a big part of the education process as well.
Yeah, I think that it is. Letting, people can miss a lot of opportunities just not knowing their rights. I mean, this is a matter of rights. You could go into a job thinking, or maybe you don't apply for a job that you could actually be accommodated for, and you just give up that opportunity. So again, as I stated before, education goes a long way on all sides of this conversation. We all want our public to be educated, and it helps us have the proper expectations and actually live together and work together more smoothly when we know the bounds of our interactions.
Vilo, in this day and age, though, where we're starting to see that employers are getting a little bit more savvy, that sometimes that discrimination is actually happening in a very subtle way. It's one thing to be overt, but it's a whole nother thing when you have electronic applications coming in, you find out you didn't get a job. How do we try to make sure that we're policing that subtle activity that's happening out there?
That's hard to do because as you said, the business owners, the bosses are becoming more and more subtle. But when they become aware of it, we need to know so that we can make sure that accommodation is happening.
Todd, there's also this EEOC process that can get you involved where prior to a form of litigation, how does that EEOC process usually take effect?
Yeah, so that's one of the things, and one of the hurdles that all people complaining of discrimination have to get through. They have to file with either the Equal Employment Opportunity Commission or its state equivalent. And that it's an easy process to start in that you just simply go online and you can file a complaint, and a lot of that you can do online and over the phone and through the mail. But yes, you do have to go to a state agency or the federal government before. You can't just go immediately and file in court. And if people are having problems, there is assistance out there and available on religion, and it really is good to reach out and get some assistance at the beginning, because there's some quirks of the law that people may not understand, and they can really do a lot of harm to themselves early on if they're not acquainted with and getting advice from someone who's familiar with this area of the law.
Tim, you mentioned the Hardison case, but there's also been some successful cases where we've seen, for example, where a young lady who was wearing a hijab with Abercrombie & Fitch, the courts end up ruling in her favor that she was allowed to continue to wear that, and to ask her not to was a violation of religious beliefs. So it sounds like we have had some pretty decent successes in spite of Hardison.
That's true, and I think that there have been chipping away at Hardison. My big point, I think that this entire conversation illustrates, is that where the rubber actually meets the road, the place where people are most likely to have their religious freedom threatened is the workplace. That's actually the place where many people, especially people that don't have a lot of economic bargaining power, face constraints on practicing their religion, like going to Saturday services or even to Sunday services, because many businesses operate on Sunday. So this is a really kind of understated thing. We talk about a lot of legal cases, but where the rubber really meets the road, does your employer accommodate your desire to practice your faith? That's really kind of at the kind of kitchen table level, a really important question about protecting religious freedom.
I'm going to let you have the last word on that, Tim, but I think this is something really important for our listeners to understand. You do have rights, and you are going to be protected. However, you have to be willing to move forward and to seek the right advice, and to understand that if you have a fundamental religious belief and there is an issue at your job, make sure to inform your employer, but then make sure to take the next steps to find out how to best protect yourself. Gentlemen, there's a case I'd like to talk about. It's called the Fellowship of Christian Athletes versus the San Jose Unified School District. This is a case in which we have seen that's been in effect for about a decade, where you had a teacher that was within this district that actually had some religious beliefs that were being ridiculed, and students were being goaded into protesting and harassing a specific club that was taking place. Justin, as somebody who's a former athlete and played at Division I level, and you see a case like this, can you give us a little bit more color as to actually what's going on and how this may work in the grand scheme of things?
Yeah, FCA certainly has a special place in my heart, but I think at the root of this are some principles that we should all kind of be following. We need organizations. When we talk about the principle behind the freedom of association, the principle behind the freedom of assembly and those rights, we have to make sure that organizations can find a place on campuses without this type of harassment. A lot of what we see going on within this case seems to be somewhat malicious. seems to be really what goes against principles of civic pluralism, where people have different beliefs. You don't agree with those beliefs. So instead of having respect for those beliefs, you try to tear the organization apart, or you try to move them off of campus, or make sure that they can't come together and associate. And we just have to do better than that. Our democracy can't be healthy if we don't treat each other in a better way. And I'm hoping that schools and other people who are in this position do better and, again, seek a more of a civic pluralism so that we can live together and groups that disagree can thrive and move forward.
Todd, what has been the success rate of seeing, these type of clubs, reinstituted or reinstated? It seems like once it starts creating, these efforts and it starts having people push in different directions, is it likely that you can end up getting this put back in the campuses?
The success rate has been pretty high, especially given that it's been over 10 years ago now. There was a case called Christian Legal Society versus Martinez that created kind of an unfavorable legal standard. And what it said was that this law school that it was against had what was known as an all-comers policy. And that policy said as long as a school had a policy that required all clubs to take all qualified candidates. So you could have an academic standard, or you could have an athletic standard, whatever, but as long as they didn't put restrictions on, that met the constitutional requirements. And that's what the school district here tried to argue. The problem is they didn't truly have an all-comers policy, right? They had other groups that did discriminate on protected categories. So for instance, Big Sisters, Little Sisters existed on there, and even though they had signed the pledge, but clearly that organization was not allowing men to mentor young girls. They couldn't do that, nor should they probably, quite frankly. There is an equivalent or organization for boys. And so there was other examples as well that they said they had an all-comers policy, but they didn't really enforce that, nor should they enforce it. There are times in which we want to have clubs that are geared toward protected groups and organizations, and that doesn't mean that they're being discriminatory. It just simply reflects the reality that we live in, right? And so there have actually been a lot of success challenging these, because most schools have realized what an all-comers policy would actually mean, and they're not willing to follow that.
Tim, the Ninth Circuit came in and actually ended up agreeing with the lower courts on this. Do you think they got it right?
I do think they got it right. I mean, I think CLS versus Martinez still remains kind of out there haunting a lot of these on-the-ground cases. I will say that 17 states in the last decade or so have passed laws guaranteeing the rights of faith-based organizations on campus. My organization has had a lot to do with those, because we do a lot of work at the state level, and it's a multi-faith effort, and I think it's a really good one, and I think more states will and should do that.
Viola, what is the struggle that's going on campuses where there seems to be this pushback regarding faith organizations? It seems like there are so many institutions that usually had been, quote unquote, more liberal or more open, and you would think in the area of academia that we would see less of this, but it seems like we're starting to see more of this. Or is this just maybe a small minority that's really causing confusions here?
Well, it seems that there's a very pronounced trend in higher education today that is directly opposed to faith, and they assault faith, and which is unfortunate, because a university usually pride themselves on being a place where there's open exchange and open discussion, but a lot of times we're not seeing that, and thankfully we're seeing the courts recognize that Christian groups have just as much right to exist as other groups do.
Todd, is this Title VII aspect of some of these issues that we see from a faith perspective, is the Department of Education ever coming in from time to time and maybe reminding these academic institutions what their role can be and how they can go about this? Or is this pretty much a lot of these groups kind of winging it on their own from what you've seen?
So yeah, the department. So just to be clear, it's Title IX that protects sex. Usually, the challenge here is state level and school policies and regulations. And the Department of Education has not always had a big role in that, because there is no protection for religion for students on federal law, or any protection sort of indirect. other than the First Amendment, the U.S. Constitution. And so what we have seen is it's been organizations like Christian Legal Society and others that have come in and trying to stand up for these organizations. In this particular case, I believe it was Beckett that represented the organizations. And so that's where we've seen these protections coming, right, is these religious rights law groups like Beckett or Alliance Defending Freedom, ADF, that have been coming in. So there has been a lot of protection there, but it does require these organizations to keep the faith, because often where the Department of Education stands, unfortunately, really depends on who's in the White House and which party is. And that is unfortunate, right? It would be nice to see, a Democratic president and administration sort of standing up for religion in these higher educational settings, and we just haven't seen that a lot.
Justin, what's the downside of this? I mean, you're one of those individuals who's been a political strategist. To see that there is a question, depending on who's in the White House, whether or not you protect these type of things that actually have federal law. What do you think that's all about?
I think the downside is that it could make people just question the principle in general, whether we really believe in it, and that's what we have to get past. Partisanship. Ideology should have no bearing on how people are treated when it comes to their rights. And that's why we need people of faith, of integrity, who are in those positions to say, hey, this is the way that it should look. We need leadership. We need leaders, presidents, and others who say, hey, when it comes to these issues, I'm not trying to play politics. I'm not trying to get into this one-upsmanship. I want to make sure that all Americans are protected, because that's what this is built on. And if I'm leading and representing everyone should be protected, and that shouldn't change from one party to the next.
Tim, you mentioned that you actually help groups that are kind of involved in some of this. What's the advice that you give an organization that comes to you and says, Tim Schultz, we'd like to start this club at our school? What's the best way to move forward with that?
Well, it's three things. One is to know that they have rights, and that the right to choose your own leader is frequently guaranteed by their own state law, and probably is guaranteed by the law of the United States, because true all-comers policies are really rare. They're really rare in practice. The second would be to make sure that you're clear in your founding documents about what your requirement for membership and leadership are. Usually these things turn on leadership decisions, but I would tell them to be very clear in their written founding documents about who their leaders can be and what those requirements are.
Well, it sounds to me like there are clear guidelines, and we're right back to organizational documents and making sure that people are kind of putting themselves in a position where they have found an alignment and staying consistent in certain ways. Viola, when you take a look at some of these decisions that we see coming down in the courts, where the Ninth Circuit came here in terms of protection, and with the Supreme Court kind of leaning to the right, as many would see, it sounds like many religious organizations, or organizations that are going to be looking to be protected from a religious standpoint, should be in pretty good stead, even as matters find their way all the way up to the Supreme Court. Is that where it looks like where things are going nowadays?
Well, we're seeing that in ministerial exception cases. We see it out of Iowa, where the university there tried to disestablish all these clubs, and the court ruled against them. So it seems like we're headed in a positive direction.
So, Todd, if we're heading in that positive direction, and I would imagine that somebody like you, who may be a litigator fighting for this, this seems like this may be turning into the golden era of being able to protect religious organizations as you find your way going up to the Supreme Court. Or is that still a court where sometimes you have no idea where things may really shake out?
Well, so the first thing people need to understand about going to the Supreme Court is that is a very long odds thing, right? I mean, the Supreme Court is a court of discretionary jurisdiction. They don't take every case that they are asked to take, and having to rely on the U.S. Supreme Court can be difficult. I mean, for instance, in this case, there were 3 judges. 2 of them ruled in favor of Christian Fellowship, and then 1 dissented and wanted to throw the case out. Unfortunately, those judges broke down by the party that they were appointed by. So the Democrat is the one that wanted to throw the case out. The 2 Republicans were the ones that wanted to vote in favor. And, it shouldn't matter what the random draw is of the judges you get, but unfortunately, that seems to happen more and more.
You know, Justin, as a former athlete, I'm going to give you the last word on this. When you see these kind of matters and you think about the camaraderie that takes place with teams and clubs that get affiliated as a result thereof, is this something that actually is more than just religion, but it's also part of the camaraderie that you pull together?
Yeah, it is part of camaraderie. And within camaraderie, within a group like this, your beliefs matter. And so when you're trying to force organizations to bring people in who don't share those beliefs, it really defeats the whole purpose of what that organization is about, and if it can carry out its mission. And so I think we need to be very cautious about this. All of us care about being inclusive, but we need to make sure that that inclusivity doesn't cut off the ability of people to gather together with people who believe the same way so that they can carry out a mission.
You know, one of the things that you look at with this too, Justin, is the idea of this mission. Is there a problem where people get a little confused because sometimes you can have subsets of that same mission? You play on the same team, but those who may be of a certain faith may find that that connection makes the team even stronger.
Yeah, I think that's a huge part of it. Finding people that you have similar beliefs with and connecting with them, but also realizing that people in other groups have different beliefs and seeing how you can wade through those beliefs. What this attempts to do is act like the beliefs don't matter. We can see eye to eye even when we have different beliefs, but the beliefs matter whether they're different or they're the same. We don't have to gloss over that and act like they don't matter. I think it's disingenuous and really harmful in a lot of different aspects.
Well, it sounds like what we're saying here is that you have the ability to really practice your faith no matter what your organization may be, and the protections are there. And sometimes that additional subset of camaraderie can actually be something that can be beneficial in the long run. Vilo, tell me something I don't know.
The protection for women under the Civil Rights Act was a killer amendment.
Wow. Tim Schultz, tell me something I don't know.
Well, it's the holiday season and people lots of times are donating to local food banks. 53% of all food banks in the United States are faith-based.
Wow. Justin Giboney, tell me something I don't know.
The Fellowship of Christian Athletes was founded in 1954 in Kansas City, Missouri.
Todd, going to wrap up with you. Tell me something I don't know.
The U.S. Supreme Court, when deciding religion case or a speech case later this term called 303 Creative, is likely to rule in favor of the website developer. And I would say it's not going to just be a 6-3 vote. We'll see if I'm right.
Wow. Well, guys, thank you very much. This was great information and looking forward to us talking again sometime soon. Thanks again for being here with us. Hope you enjoyed our conversation. Just remember, if it's about God and government, it's faith and politics. See you next time.